Late 2008, the collapse and the death. In the closing months of 2008, as the national economy convulsed and banks once trusted were remade into headlines and acronyms, a death occurred that would redraw the architecture of my life. The financial collapse did not cause the death, but it did change the coordinates in which families made care decisions. Savings that had once felt immovable became fragile, trust in institutions felt suddenly conditional, the small economies of daily life, who could afford home help, which relatives might be pressed to liquidate a keepsake, shifted overnight. That winter, when the world seemed to tilt, my mother's passing precipitated not only grief but a cascade of administrative entanglements that would not be contained by ordinary mourning. Before the public unraveling began, my mother had taken a private, resolute step. She sealed a short recording in an envelope, closed it with warm wax impressed by her thumb, and entrusted that object with a kind of binder's moral force. She treated the envelope like a last will of voice, not a full legal instrument but an act of authority. It was recorded and hidden years before the trial. It would later be something people wanted to monetize, archive, dramatize, and, in one alarming moment, vandalize a fence to advertise. The wax seal, the brittle cassette, the thumbprint. These were small, stubborn relics that proved stubborn in return. The estate moved through probate and into contested litigation. The formal steps stretched and multiplied. Papers were filed, countersigned, stamped. Letters from fiduciaries used a tone that suggested the machinery of law was neutral, objective. It is never neutral. For months the house became a theater of small reckoning, late-night phone calls, invoices I had not expected, an executor whose decisions I questioned. The process, stretched across 18 months, forced ordinary domestic choices into the glare of procedural form. Spring 2010, the trial, the judgment, and the ordinary gravity of law. The litigation reached a public conclusion in the spring of 2010. The trial wound through hearings and testimony, and on a bright March morning the judgment was pronounced. On paper it read like a docket entry, dates, counts, orders. It read like a clean close to a case. In person, under the high ceiling of the courthouse, the sentence felt quieter and smaller than the private stakes it purported to resolve. The judge's voice had a particular, ordinary gravity. A clerk's stamp sounded like closure. We left the building with the kind of shock that registers not as dramatic catharsis but as a slow realization. One public stage had ended and another, less visible, had begun. The judgment did not mean the ledger had been closed. Probate had made public what our family had hoped to keep private. It also demonstrated a simple institutional truth. Law measures with forms, signatures, and dates, but the ledger room counts only what fits the narrow metrics of courts. The erosion of small acts of care, the missing conversations, the grocery trips unmade, the slow distractions that become neglect, was not wholly enterable into that ledger. 2010 to 2015, the ledger room and the second life. After the trial, an unexpected and sustained attention attached itself to me. Strangers began to write, often beginning their messages with the same humility. I don't know how to say this. And then layering dates, names, and small, raw accusations. A neighbor who had maneuvered into an elder's trust, an attorney whose fee-driven shorthand confused duty with profit, a caretaker who omitted those small mercies that make a last season bearable. These inquiries were structured like depositions, details, times, names. They arrived in my inbox as if I were a town magistrate in a modern era of private calamities. What followed could be described as a second life. From 2010 through 2015, tending correspondence, composing templates, compiling lists of elder law attorneys, drafting sample letters to banks, these became a form of civic work. I advised people to record last acts of authorship before memory faded. I urged them to document decisions when fear was the conductor of choices. I counseled on practical steps, when to get counsel, how to notarize a statement, what a careful chronology should include. Sometimes my replies were bluntly procedural, sometimes they struck a pastoral tone. Mostly they were pragmatic. There were moments when the work became ritual and moments when it felt like ministry. Necessary labor, neither heroic nor infinite. The ledger room itself was both literal and metaphorical. It was a small space lined with binders and manila envelopes, a lamp's soft sheen on a scarred table. Evidence sat there like furniture. On good days the ledger room was a study in what had been done and what still required tending. On bad days it felt like an indictment, A small shrine to a civilization that tolerates tidy crimes when people are tired, pressed, or simply distracted. In the ledger room I learned to love the tactile certainties of paper, the scratch of a signature, the scent of edges softened by tobacco and handling, the small toughness of a bill that insisted on being read. July 2011. A summer knock and lemon squares. By July 2011, the public portion of the case had been concluded for more than a year. Summer arrived like a decision. Hot and slowing the street, porch boards that glowed in the sun. On a July afternoon she came, carrying a tin of homemade lemon squares and an apology she said she did not want to make in public. She stood on the threshold, hesitated, and knocked as if rehearsing the exact angle of contrition. When I opened the door she presented the tin like a relic she had kept too long, the pastry wrapped in the scent of sugar and the memory of an attempt at peace. She said that her brother had been frightened and had made choices he could not reverse. The words were both explanation and confession braided together, an effort to translate cowardice into some human accounting. The lemon squares tasted of summer and truce. I accepted the pastry and declined the easy absolution. Certain ruptures are not mended by an afternoon and dessert. Still, the gesture revealed something the courthouse could not. Wrongdoing rarely arrives in a single dramatic act. It enlists small, daily departures from care, performative cruelty leaning on cowardly retreat, and when this erosion accumulates it becomes a moral ledger the law does not always measure. 2012. A cousin's accusation and the small cruelty of presumption. In 2012 a cousin, distant, the sort dispersed across holiday lists and loose condolences, sent an email accusing me of turning family grief into spectacle. He implied the litigation was less about justice and more about ambition, that my insistence on accountability was self-serving. His tone was swift and judgmental, the easy cruelty of someone who presumes transparency of motive and measures virtue by public visibility. I did not reply. I filed his message into a shoebox with other small abrasions and returned to the work of answering people whose needs were concrete and urgent. Critics like that read like a second grief, an expectation that others will pay penalties the critic himself has never tallied. July 2013. A child's popsicle and the house reclaimed. One bright July afternoon of 2013, a year that felt too cheerful compared with my mood. A neighborhood child, about 8 years old and once the boy who had sat in my lap to ask how the toaster worked, showed up on the back steps with a melting popsicle. For an hour the house reasserted itself as my mother had intended, a place where ordinary things happen and people can forget private wounds long enough for play. The child clumsily threatened the piano, found a tentative melody, and made me laugh. For that stretch the ledger loosened its grip. That is one of stewardship's curiosities. The object you guard can also become the stage for life. The envelope's status had shifted too. What began as a weapon, an assertion of a dying woman's voice, moved toward relic. I took it out sometimes, like lifting an old photograph to see whether time had smudged its edges. The wax, warm under her thumb, had the texture of skin. Inside the cassette was a brittle hello, the voice itself. I listened on nights of doubt. In the cheap hiss of the tape, in the crackle of a laugh, was something a transcript cannot capture: timbre, joke, the slight softening of consonants. The recording functions as private liturgy more than evidentiary proof. It is a reason to continue. Offers, proposals, and the commerce of grief. As years passed, the envelope attracted attention beyond neighbors and the curious. Producers and agents saw a tidy narrative in the cassette's grain, a recording to dramatize, a ledger to monetize. A producer with measured steps wanted the tape, as if my mother's voice were raw material for someone else's dramatic arc. A literary agent's email smelled faintly of perfume and contract paper, promising that the story could be parceled into installments and saleable arc. I refused most offers before thinking fully, sometimes out of principle and sometimes out of pride. Refusal became a posture for a while. But refusal is complicated. It can protect a scar and also hoard a story from potential reform or reckoning. Touring the ledger, seminars, council hearings, modest reforms. A different, quieter path emerged when I agreed to talk. In 2014, I gave a sequence of seminars at community centers and neighborhood halls. Initially, acceptance felt like an afterthought, a practical answer to incessant emails. But these sessions opened a space for people to convert rage and fear into bureaucratic verbs. notarize, subpoena, petition. At one of these sessions, a local councilwoman attended as a listener rather than as an authority. She had heard local rumors of estate abuse and administrative opacity and found my specific testimony a useful counterpoint to abstract concerns. Her staff folded my notes into hearings, and in 2015 and 2016 those hearings produced proposals for clearer oversight and stronger notice requirements for named heirs and executors. The reforms were modest and technical. Rules about mandatory notices, time frames for contested accountings, but they mattered. They were sewn patches in roofs over other people's homes. The work of community education became its own ledger. I drafted templates, detailed checklists for heirs, precise questions to ask a fiduciary, sample letters to banks. I learned to translate legalese into actions that people could perform while exhaustion still weighed on bones. The reward was small and practical. An older woman calling to say she finally felt brave enough to speak to her father about the power of attorney, a neighbor sending a photo of an elderly woman now visited without fear. These notes I keep in a file, not as trophies but as markers of the ledger's capacity beyond punishment. 2010s, vandalism, surveys, and the public appetite. As attention grew, the ledger became visible in ways I had not anticipated. One humid night someone spray-painted a slogan across the fence, "Truth sells." The fresh paint smelled of menace and mockery. A neighbor's security camera captured 2 silhouettes. I filed a police report. The officers were kind but practical. They suggested I might consider moving for safety. That suggestion felt like a peculiar surrender, an invitation to privatize grief so the public could return to comfortable ignorance. The spray paint made clear a hazard I had not wanted to acknowledge. Once an object becomes public drama, it attracts predators and opportunists. A stranger with a professional veneer appeared at the gate with a business card and an insistence that he could archive the envelope in a climate-controlled case. He spoke the language of museums and benefactors. He wanted access under the rubric of safekeeping. I refused. He left his card, and it lives in a drawer near the wax-like proof that taste and opportunism share an address. That drawer itself resembles a ledger. Cards promising safekeeping, proposals, and polite refusals stacked like unpaid bills. A sibling's accusations, confessions, and the brittle negotiations of family. Family responses were varied and ongoing. One late Tuesday night a sibling called with the thin voice of old arguments and a new charge, that I had hoarded grief for profit. The accusation was threaded with long resentments, that grievance could be currency, that suffering performed could be rewarded. Accusations and apologies passed like tides. The call ended with no resolution, only loneliness, as if a piece of family had been posted to a notice board and sold. Other encounters were quieter. One sibling, distant during the litigation, arrived at the kitchen table with a battered tin of my mother's shortbread. She confessed she had sold some of our mother's things. Some, she said, out of necessity, others furtively because she needed money. The admission was less excuse than entreaty. She left the tin and, on her way out, brushed the ledger room door with her fingertips as if promising she would return. That scraped confession did not close anything but opened a new seam from which some domestic repair might eventually proceed. Instances of pettiness and exhaustion. Keeping the house has not always been virtue. Invitations, weddings, dinners, graduations, arrived, and I often declined them. I told myself I was preserving reverence for what was lost. More honestly, avoidance was sometimes about the person I had become and whether I wanted to find myself defined by the ardor of resistance. Solitude kept the ledger tidy and my vigilance sharp, but also made me brittle. There are nights I imagine a different self, someone who would have sold the house, taken a smaller place with cleaner lines and fewer ghosts. The phantom of an easier life arrives with a small, insistent ache. Yet sometimes those small domestic choices produced surprising moments of grace. A child's laughter in the parlor, a neighbor bringing soup, a sibling sharing a memory. Ordinary trade that slowly rebuilt a domestic commons. These were not grand reconciliations. They were small vectors of repair, and they multiplied. Maintaining the ledger, forms, calls, and mundane justice. The work of custodianship often reduced to bureaucracy. I made phone calls to banks to freeze accounts, filed appeals, traced signatures appended by shaking hands. I verified wills, investigated duress, organized witnesses. There were afternoons spent with printed forms and envelopes, evenings with receipts and timelines. Each tedious, exacting task patched another leak. People came to the ledger room with photographs and receipts. They sat across from me and told stories, each a variation on the pattern I had learned: neglect dressed as legal fiction, guardianship confused for convenience. They arrived fragile and furious, seeking steadiness, a place to name what had been taken. I learned to be precise in language and gentle in tone. My authority was narrow and earned in the dirt. It was not law school knowledge. But the ledger room provided a breathing space, a place to convert grief to process and indignation into something actionable. The recording, the envelope, and the voice. The cassette in the waxed envelope is its own stubborn presence. When I press play, the cheap tape opens a window to a time when my mother's presence was fuller and her fatigue less certain. Her voice, lifted from the blur of decline, speaks with a clarity legal documents sometimes lack. She names things with an authority in life she had been denied. That act of recording was an assertion of agency, to be heard after fatigue, to claim a voice that could outlast the limitations of the moment. The cassette is not only evidence, it is liturgy. It reminds me that truth unaccompanied by caretakers becomes myth. Caretaking without generosity becomes tyranny. The recording asks for fidelity, not for spectacle. It asks that I remember both what was taken and what might yet be done. Public offers and the moral labor of refusal. Proposals continued to arrive: podcasts, documentaries, dramatizations. Each offered an audience and threatened reduction. A producer's firm handshake and clear eyes could not disguise that the ledger would be reshaped to fit a narrative arc. An agent's note, perfumed, contractual, promised tidy chapters and serial income. I refused often because the offers seemed to turn my mother's voice into a commodity and my decisions into plot beats. Refusal became a way to protect the fragile authority of the cassette from those who would reframe it for clicks or ratings. But refusal demanded a cost, diminishing possible public understanding that could have come from responsibly told stories. Vandalism returned once, and with it a renewed sense that the ledger had become a spectacle. The fence's spray-painted slogan "Truth Sells" remained for a few weeks, photographed, attached to law enforcement records, sparking the latter-day suggestion that I might consider moving. The ledger's custodianship had become a public object I could neither comfortably disclaim nor fully possess. Small reforms and real consequences. There were modest victories. The councilwoman who had listened in 2014 shepherded hearings that produced clear, enforceable proposals in 2015 and 2016 for improved notice requirements and oversight. Changes were technical: deadlines for notifying named heirs, clearer standards for contested accountings, requirements for independent audits in certain contested estates. These amendments did not make headlines. They did, however, close off some spaces where predation once slipped under procedural rugs. They were stitches in the fabric that keep other families from being exposed to the same erosion. Teaching, community work, and a ledger that is not an altar. Teaching became an unexpected consequence of stewardship. I led sessions at community centers where neighbors shared stories and learned the craft of turning lament into recognizable claims. After one session, an older woman approached and said simply, "You made me see the point of paperwork." Her voice was grateful rather than accusing, and in that gratitude I found the ledger's true yield. Little victories, phone calls that froze an account, a notarized letter that prevented an unwanted sale, were the real measure of the effort. As the town's memory of the scandal receded into rumor and column inches in the mid-2010s, more letters came in, thank yous from those whose actions I had forced into daylight, notes from people who feared their own probate encounters. Some were tender. Others were practical, references for attorneys I trusted, short lists of firms to avoid. I keep those notes as reminders that the ledger can be a tool used for living rather than an altar of grievance. The ethics of keeping, offers, pride, and a sibling's tin. Monetization offers continued to test the border between principle and vanity. At first my rejection felt principled. Over time the refusal sometimes read like pride. A late-night sibling call accusing me of hoarding grief for profit forced a cramped negotiation of motives. Was the refusal protection or ego? We ended the call lonelier, with old resentments recalibrated by the new accusation. The sibling who confessed to selling items returned with a battered tin of shortbread. Small theatrical gestures like these do not undo what has been done, but they mark an opening. She touched the ledger room door as she left, a fingertip on painted trim that felt like a tentative promise to return. It did not close the wound, but it admitted that family can be fragmentary, accountable, and undone in the same breath. Maintaining the home, rituals, repairs, and daily fidelity. Maintenance, mundane, exacting, ceremonial, became the frame of my days. I wipe piano keys before anyone sits so as to remove the residue of argument, run a thumb along book spines in the parlor, confront rot with brushes and sealant in the fall. These acts are neither purely symbolic nor purely mechanical. They are functional maneuvers through a house that insists on care and, in caring, reclaims life. Clean sheets, made beds, a stove carelessly scoured. These are the small rituals that say aloud what the courthouse could not: we will not let everything go to seed. Sometimes the house feels like an archive, sometimes like a stage. I have used it as an after-school room for neighborhood kids, an informal meeting place where people speak of elder law without the cold glare of judgment, a place to host a small seminar. The ledger room endures but has become less central in a domestic life that continues to accrue ordinary use. The house no longer revolves solely around grievance. It is an inventory that lives and moves with the rituals of every day. If you find an envelope, a caution and a covenant. If someone else opens a similar envelope, they inherit more than a recording. They inherit a domestic politics. Opening such an envelope will place you inside a public architecture you did not choose. You will be praised and attacked, less alone and more exposed. There will be no surgical closure, only daily maintenance. The act of opening is not binary. It is a choice that reshapes relationships, household economics, and the way neighbors and strangers will view your doors. The ledger taught me this: truth arrives with consequences. You cannot place a truth down and walk away. Once you assert it, rooms open that require tending. Neighbors will choose which furniture is worthy of preservation. Others will use your family as a parable about the perils of airing laundry. Public narratives transform individuals into instruments for larger arguments. The envelope is both an instruction and an indictment. It insists that someone hold a story accountable in a world inclined to forget. The present, a house kept, a voice honored, and maintenance as fidelity. Now, in the slow blue of evenings, I take the envelope out and let my mother's brittle recording fill the kitchen like weather. Children return with melting popsicles and ask to hear the story. I press play with small theatricality and let the thin audio spread across the table. The child listens for cadence, for the fracture of a laugh, without hunger for scandal or law. Afterwards, purple smears on the stoop, and the ledger loosens its grip. Stewardship becomes less about evidence and more about fidelity, to a voice, to a demand for consequence, and to the messy business of family. I still refuse many offers. I keep the envelope folded and the wax dulled from touch. But I have invited the house to assume other small functions: an after-school place for homework, a meeting room where people can talk elder law without the cold glare of judgment. The ledger room endures but is less central. The house is imperfect, paint flaking, timbers sighing, and yet I have not sold. It feels like a pact I made to a voice and to an instruction that asked to be kept. If the envelope taught me anything beyond vigilance, it is this: truth without caretakers becomes myth. Caretaking without generosity becomes tyranny. The daily work is choosing which failures to avoid and which to live with. I do not always choose well. I am petty at times and brave at others. Mostly I continue because the brittle recording keeps asking me to remember not only what was taken but what might yet be done. After so many years, the work is not closure and it is not absolution. It is maintenance. I wipe the piano keys, answer urgent letters, draft precise lists for a neighbor worried about a power of attorney, meet people who come with receipts and photographs, and hold a child's hands as she learns a clumsy melody. I refuse some invitations, open other doors. I tend the rooms and keep the envelope because my mother asked me to keep the story alive and to let that story ask for consequence in a world designed to forget. Maintenance will have to be enough. Maintenance will have to be enough. Yet maintenance, over the years that followed, accrued a history of its own. In 2017, the quiet fidelity of daily care collided with the theater of courts. I filed a petition in probate that year. Not because I imagined the cassette would magically transmogrify into a new will, but because the recording, the envelope, and my mother's spoken intention demanded a legal reckoning. I sought two things: an adjudication that would honor the moral force of the recording, and a procedural accounting of how a formally executed will could leave intact a structure of dispossession that the voice plainly rejected. The petition named dates and documents. It referenced the existing will, the sealed wax envelope, and my mother's recorded statements as evidence of her settled mind. It asked the court to consider extrinsic proof of intent in a case where the formalism of signature and witness had insulated an outcome many considered unjust. The first hearings were in March 2017. They were not cinematic. They were hours of a clerk's dry dictation, the rustle of exhibits, and little human intimacies that are not visible on television. A probate judge reviewed statutory text. Older statutes that had allowed formal wills to trump other declarations unless extraordinary proof of subsequent testamentary intent could be shown. The judge asked about chain of custody for the cassette and whether playback could be authenticated without tampering. I had, by then, paid for audio forensics, spectrographic comparisons, a report that identified breath patterns and idiosyncratic consonantisation consistent across known recordings of my mother. The forensics, dated June 2016, became an exhibit. The opposing counsel filed a motion to exclude the tape as unreliable. My siblings retained counsel who argued the recording was private, inadmissible, and that the will, clear on its face, should stand. What mattered less in that courtroom were my motives than the law's appetite for simplicity. The county docket for 2017 filled with cases that week: evictions, guardianships, contested conservatorship. In the late 2010s the courts wrestled with an aging population and an increase in posthumous disputes, and judges were learning to balance strict probate formalities with the messy reality of family life. The reforms the councilwoman had shepherded in 2015 and 2016, deadlines for notifying named heirs, clearer standards for contested accountings, and requirements for independent audits in certain contested estates, began to matter here. Because the will in question had been paid out without contemporaneous audits and because certain notice thresholds had not been met, the court had statutory hooks to examine the estate's administration even if it declined to treat the cassette as a testamentary instrument on its own. A bench ruling came in September 2017. The judge did not declare the cassette a will. Instead, the ruling created a different remedy. Noting the statutory reforms and the public interest in transparent administration, the judge found that the estate had been distributed in a way that violated the then-existing notice requirements and that the administrators, my siblings, had failed to produce a contemporaneous accounting sufficient to rebut allegations of self-dealing. The remedy was pragmatic: an order for a full forensic accounting, the return of certain liquidated assets into a receivership, and a requirement that the estate be redistributed subject to the court's equitable powers. The judge cited the recording repeatedly in her memorandum opinion, not as a legal substitute for the formal will but as persuasive evidence of intent and as moral ballast for equitable relief. Her language acknowledged that statutes cannot wholly contain the commitments that people make in private. The law, she wrote, must sometimes operate to ensure the public trust in familial transfers and to vindicate the expressed, but not formalized, wishes of vulnerable persons. The accounting revealed transactions that were, in the cold light of summaries and spreadsheets, difficult to defend. Loans that had been repaid in promissory notes but not reflected in ledgers, transfers of artwork to a sibling's name with receipts that predated the estate's distribution, a pattern of billing for care that did not correspond to calendar entries. Each instance had its own story, a justification, an omission, a misremembered conversation, but together they formed a pattern that the court could not ignore. The forensic report submitted in February 2018 included timelines, bank reconciliations, and a recommendation that certain assets be returned to the estate and redistributed under court supervision. The redistribution took almost a year of settlement negotiations, mediation sessions in mid-2018, and a final approval order in February 2019. What the settlement did, and did not, accomplish mattered in social as well as financial terms. The court-ordered redistribution returned enough assets to fund a trust for long-term maintenance of the house and to allocate modest payments to me and to each sibling. The ledger room, its ledgers, its ledger desk, the packets of correspondence, remained physically intact in the house. The settlement constrained the worst excesses of an informal family economy based on favors and late-night promises. It did not, however, fully remedy the injury of being written out of a life. No court could compel affection or erase the half-decade of silence and evasions that followed my mother's final years. What it did do was make certain that the house would not be sold precipitously and that the envelope's instruction, the moral demand that someone keep the story alive, would be possible to fulfill. The local press told this as a slow, procedural victory. Columnists argued in November 2019 that the case was emblematic. It demonstrated why statutory reforms were necessary and how community vigilance could translate private grief into public protections. The councilwoman, whose first hearing in 2014 had felt, to me, like a small and surprising act of recognition, gave a statement that winter about the importance of access to legal aid and older residents' rights. The state legislature took interest. In the 2020 session, a bill loosely related to the county reforms, requiring clearer notice to non-probate heirs and expanding funding for legal clinics serving elder constituencies, found bipartisan support. It was not a sweeping moral correction, it was incremental lawmaking, line-item appropriations, narrow definitions, and a new grant program for pro bono probate counsel. Still, the statute passed and was signed into law in May 2020. The text included a clause acknowledging the salutary role of equitable remedies in probate when procedural lapses occurred. I read it like a small, delayed nod to that wax-sealed envelope on my kitchen table. Those years were also a reckoning in smaller, more private ways. Sibling relationships, once bridged by shared childhood intimacies and by my mother's domesticated rituals, had turned into transactional correspondences. Reconciliation arrived slowly and without ceremony. In 2019, one sister began attending the community elder law sessions I led. She wrote an op-ed about the injustice she now recognized. Another sibling, whose name still prickled my memory when I was alone at night, agreed to participate in mediation and to sign away a claim to the ledger room's custodial authority. In therapy and through mediated conversations, we began to acknowledge the accidents of history, the ways illness and proximity had been leveraged into advantage. Those conversations did not restore trust. They set a landscape in which small acts of accountability, an admission, a restitution payment, a shared custodial calendar, could be measured and repeated. In 2020, during the global pandemic, the House performed other civic functions. The local schools asked if they might store a supply of laptops in the parlor for families without access. I agreed. The ledger room became, for a time, a classroom for Zoom lessons. The piano sat as a distant witness to math instruction and to the mismatched laughter of kids trying to find a rhythm in uncertain remote schooling. These small public acts felt like repairs to a civic fabric that had been fraying long before the cassette made headlines. People brought masks and takeaway dinners, and the house filled with the muffled, ordinary music of neighbors helping neighbors. The envelope remained on my person more than before. I had started to carry it in a small inner pocket when I drove the kids to outdoor classes or to grocery runs, as if that touch could anchor me against the unfamiliarities of 2020. The cassette itself continued to be a contested cultural object. In 2021, a graduate student reached out, offering to include an anonymized excerpt in a scholarly paper about posthumous voices and legal testimony. I consented on condition of privacy. The excerpt, snippets of my mother's cadence, clipped and contextualized, appeared in a journal in 2022 without identifying detail. Its footnotes discussed the ethics of using intimate recordings and the difficulties of balancing privacy with public import. That publication prompted an invitation from a small, academic radio series that wanted to explore the case as part of a broader investigation of inheritance and gendered expectations of care. I declined. My reasons were not purely principled. The ledger's lessons felt too close to home to be fully digested in a narrative designed to be broadcast. Each acceptation or refusal felt like a moral and a practical negotiation. Was it better to risk commodification for the sake of education, or to keep the envelope locked in amber? There were personal losses in those years too. My mother's piano, after decades of URLs and small concerts, lost a key in late 2021. I hired a tuner in January 2022. He slid the fallboard open and hummed at the instrument's history. He said, as he tightened the action, that the house had a sound in it that took time to settle. In the same month, a neighbor died. Another family across the street moved in with small, furtive renovations. The house continued to change, not because of legal instructions but because life does what law cannot entirely command. it wears, it accumulates, it sheds. By 2023, my role as steward felt less like a protest and more like an occupation. I had become, in some ways, what my mother asked me to be, a custodian of stories and small things. I taught more consistently, a monthly clinic on how to read a bill of sale, how to identify suspicious transfers, how to preserve emails and bank statements. We practiced filling out simple forms. I showed people how to notarize a healthcare proxy correctly. These sessions were practical, and yet, because of the envelope on my kitchen table, they were also moral. I would play, as an exercise, a 10-second clip of my mother's voice, the cadence of a name pronounced with care, and then ask participants to consider what it meant when the spoken word and the executed document diverged. The class never had more than 15 people. They were neighbors, friends of friends, and a few earnest students. They taught me that storytelling in small rooms can be powerful precisely because it lacks the glamour of national platforms. It embeds knowledge where it can be used practically. There were also moments of tenderness. In 2024, my niece, then 12, wanted to learn a piece my mother loved. We sat at the piano in August, and as her small fingers found a phrase, my mother's cassette played in the kitchen, its brittle audio filling the house like weather. The child did not care about precedent. She cared about rhythm and about the warmth of the sound. Afterwards, she put a sticky note inside a ledger, a child's script promising to keep the music. That note sits now between the pages where my mother's bills and postcards were once filed. It is a small and improbable witness. The ledger itself, the physical book of accounts and lists, continued to be a locus of disputes and a tool for repair. I digitized it in 2022, not to perfect an archive but to make it searchable. The act of scanning decades of annotations revealed patterns I had not seen in the margins. An older neighbor's name repeated as a creditor, an annotation about garden seeds that linked back to a wartime letter my mother kept. These marginalia humanized transactions and reminded me that estates are not only about property but about relationships and decisions made in moments of scarcity. Public offers of monetization did not, for the most part, stop. There were more polite refusals, offers with more legal nuance, and in 2023, a modest proposal from a university press to publish a short memoir about the case that would treat the envelope as an archival artifact. I considered it and then declined for reasons both moral and tactical. The envelope had transformed from a sealed piece of evidence into a civic instrument, something that enabled conversations about law and care when kept in a community, not packaged for mass consumption. As the years advanced, I felt the cumulative effects of this stewardship physically. My hands, which had once been nimble with ledger entries and piano keys, developed a stiffness that winter. I saw a doctor in October 2024 and learned to incorporate gentler motions into my maintenance regimen. Longer rest between repairs, fewer late-night drives to the post office, more delegation where it made sense. Delegation felt like a concession and also like a practical recognition that stewardship is distributive work, not a heroic isolation. I hired an assistant to help manage the schedule for community sessions and to field some of the offers that came in so I could maintain the house and play small music with my niece. Sharing responsibility did not feel like betrayal, it felt like the moment when the story, my mother's voice, the cassette, the ledger, lived beyond a single pair of hands. Still, the envelope remained in its wax and in my pocket on certain days. I told myself that I kept it because she had asked me to keep the story alive. I told myself that I kept it because the house needed a promise. But I also kept it because sometimes the world needs a stubborn object, a relic that resists simplification. The cassette, the wax seal, and the ledger together continue to do their peculiar work. They provoke, they instruct, and they anchor me to a set of obligations that are both private and public. There is no tidy moral here. The settlement of 2019 settled certain accounts but did not purge grief. The 2020 statute fixed some procedural gaps but did not ensure that every family would live rightly. The community clinics teach practicalities but do little to guarantee affection. What the years have taught me, in a chronology that runs from a councilwoman's hearing in 2014 through court dockets in 2017 and the legislative session of 2020 to the small, domestic tasks of 2024, is that stewardship is an ongoing political and material practice. It is law and kitchen table, policy and piano, ledger and laundry. The sealed envelope changed a single distribution in a will, and in doing so it opened a longer story about how a town cares for its elders, how law can nudge behavior, and how private truth can demand public consequence. I continue with imperfect fidelity, because to keep a story alive is not to finish it but to hold it open long enough for others to learn how to bear it, and for those lessons to be passed down in sticky notes beneath the ledger's pages and in the tentative, accurate fingers of a child learning an old melody. In the winter of 2025, the town's small historical society asked to see the ledger and the cassette. They had read the op-ed and the graduate article and were mounting a modest exhibition on civic life in the pandemic years. I met their curator in February by the library's back door, carrying a digital copy of the ledger on a USB stick and a playback of the cassette on my phone. I did not bring the original tape or the wax-sealed envelope. The curator, a woman who wore her hair in a quick bun and who had a habit of tapping her pen against the notebook in a way that suggested she was counting out possibilities, asked me if I would consider depositing the originals in the Society's newly renovated climate-controlled vault. I told her I would think about it. The thinking stretched across seasons. It threaded through routine repairs to the house and through afternoons spent with my niece at the piano. It threaded through emails with my assistant, who in May 2025 began coordinating a rotating schedule of volunteers to keep the house open one afternoon a week for people who wanted to consult the digitized ledger or to talk about estate planning. It threaded through a conference call in June, when the Town Council's Elder Advisory Committee invited me to speak about the custodial instrument the envelope had become. They asked hard, practical questions. What did it mean to hold an object in trust for a community? How could the town ensure that the envelope's status as both a private relic and a public lesson be respected? In response, I drafted a short, plain-language protocol that described access restrictions, conditions for reproduction, and a clause that any scholarly citation of the cassette would require a 12-month notice period to allow living family members to comment. The Council incorporated aspects of the protocol into a non-binding guidance document in July 2025. The document drew on the 2020 statute's language about procedural safeguards in probate proceedings, and it attempted to extend the ethos of that statute from courtroom practice into civic custodianship. There were new overtures. In August, a small regional documentary team from a nonprofit in Providence reached out by email and then by call, proposing a project that would focus less on my mother's particulars and more on how communities could reimagine accountability. I listened politely and then declined. The old impulses to say yes had shifted. Declining, increasingly, felt like an act of stewardship. I would not say no out of rigidity but out of a sense that some narratives are better transmitted in slow, local patterns than in compressed, global arcs. I offered, instead, to help the filmmakers locate archival materials and suggested they attend one of my monthly clinics in September so they could see the work in practice. 2 of them came, stood near the back, and took notes while I demonstrated how to notarize a power of attorney and how to document a chain of custody for small, non-probate objects. One of the filmmakers later wrote to say that they were more interested now in the pedagogy than the melodrama. I understood what they meant. The sibling relationships continued to evolve on their own cadence. In October 2025, another sister, one who had been quieter during the mediation years, sent me a photocopy of a letter my mother had written in 1996, a short note about oysters and the stakes of thrift during a bad winter. She attached a message, "Found this in a shoebox. Thought you might want it digitized." The message arrived like a small ceasefire. In November, after a community session where we practiced filling out a conservatorship form, that same sister attended, sat at the back, and asked a question about durable medical powers. She did not mention the envelope. I did not bring it up. Sometimes reconciliation is the pattern of returning to the same room. Even as the social fabric mended in modest ways, the material fabric of the house continued to demand attention. In March 2026, I contracted with an archivist recommended by the Historical Society to assess the physical state of the cassette and the ledger. He arrived with a magnifier, a humidity meter, and a patient manner. The cassette, he said, showed signs of binder degradation. The magnetic tape was brittle in places and risked losing audio if handled too much. The ledger's paper, though thick and cottony in the older sections, had begun to show foxing along the edges. He produced a report in April recommending limited handling, digitization in a lossless format, and the placement of the originals in a fire-resistant, humidity-controlled box. He also suggested a legal instrument, a memorandum of understanding between me and the Historical Society specifying ownership, custody, access, and the envelope's special status. The memorandum would be explicit: the physical cassette and the ledger could be accessible to scholars under supervised conditions. The wax-sealed envelope would remain unopened and would be catalogued as an artifact of contested distribution, with access deferred until either a specified date or a judicial order. That formulation appealed to me because it honored both privacy and public learning. The memorandum was signed in July 2026. The Society's board passed it by a unanimous vote at a meeting where several older members, who had their own scars from probate disputes and from relatives who had disappeared into institutions, spoke quietly about the difference between ceremony and remedy. The physical transfer took place in August. We transported the items in the back of my car, and for the first time since 2017 the envelope sat on the table of a room that was not my kitchen. I watched a curator place it, still sealed, into an archival box and then slide that box into a larger container before they closed and latched a climate door. We signed the accession forms in ink. We photographed the hands that passed the objects from one custodian to another. I felt a tightness that was equal parts grief and relief. In the signed memorandum there was a clause that allowed me to retain the right to veto any public release of audio beyond the anonymized excerpts already published. I kept that right not as an act of proprietorship but as an act of watching over how the story would be told. The presence of the originals in an institutional vault did not, as some imagined, make the envelope inert. If anything, it intensified the conversation about custody. In October 2026, a state legislator recalled the case during a hearing on elder custodial property, and referenced the Society's accession as an example of community stewardship. The hearing did not produce a sweeping statute, but it did prompt a small amendment to a consumer protection bill that strengthened safeguards for non-probate transfers involving media and personal papers. The amendment referenced the 2020 statute's earlier changes in probate procedure and cited the local experiment, with archival custody as a model for how municipalities could partner with local historical societies to protect vulnerable objects. I testified at that hearing by video and described, in measured terms, what had worked and what remained risky: the possibility of digital leak, the contortions of familial expectation, the way public curiosity can feel like a pressure to commodify grief. The cassette, in parallel, entered another layer of care. The archivist arranged for a conservation-grade transfer, a digitization in a high-bit, archival WAV format, and, separately, a preservation audio edit that removed background hiss but retained cadence and timbre. The archivist and I agreed on a small buffer: 2 secure, encrypted copies would be held by the Society and by a university research library under strict restricted access terms. An additional access copy, lower resolution and anonymized, would be made available for teaching purposes, to be played in supervised seminars. Those arrangements took until January 2027 to finalize. In the months that followed, a small group of graduate students used the anonymized clip in a seminar on oral history ethics, and a paper presented at a regional conference in March 2027 discussed the cassette as a test case for posthumous voice in legal disputes. I attended the conference as an audience member and, afterwards, met with 2 students who asked practical questions about how to honor both privacy and public value. Their curiosity felt like a small, hopeful continuation. At home, life continued in its domestic exigencies. My hands, which had stiffened in 2024, adapted to new routines. I began to use a stylus for ledger notes, and I traded late-night photocopying for morning sessions when my fingers were warmer. I saw a rheumatologist in April 2027 and learned to divide maintenance tasks across days. Delegation deepened. The assistant took over logistics for community clinics entirely, while a neighbor, an elderly man with a steady gait and a fondness for the piano, volunteered to tune the instrument twice a year. The niece, now 14 in 2026 and 15 in 2027, began studying composition. She wrote short, tentative pieces that triangulated memory and weather. She sometimes placed a page of music inside the ledger near the child's sticky note from 2024. That small addition felt to me like an act of succession that required no legal instrument but instead a practice, where the paper sat, where hands rested, where memory could be reconstructed by touch. Not all pressures eased. A podcaster in late 2027 made an unauthorized attempt to gain access to the digitized clip by issuing a public records request framed as archival interest. The Society's counsel denied the request, citing the memorandum and the access restrictions. The podcaster wrote an equivocal public piece about gatekeeping that attracted a few sympathetic comments online. The piece prompted 2 responses. A neighbor who had once been on the receiving end of a caretaking scam wrote to the society to thank them for preserving boundaries. A scholar who had used the anonymized excerpt in a classroom sent a small donation. Those mixed echoes underscored that stewardship often meant defending the conditions of care against instrumentalization. In 2028, an initiative at the county level offered a modest grant for civic stewardship projects. The Historical Society applied, with my support, to fund expanded access workshops, sessions that would teach other community organizations how to draft memoranda like ours, how to digitize delicate media, and how to set ethical boundaries that balanced preservation with privacy. We received the grant in June 2028 and used it over the next 9 months to convene 3 workshops. Attendees ranged from small-town librarians to health justice advocates. We practiced filling out forms, we role-played contested access scenarios, and we worked through a hypothetical. When does a private relic become a civic archive, and who decides? These conversations were not decisive in a legislative way, but they changed local practice. A library in the neighboring town adopted our memorandum template. A faith-based elder care organization reworked its intake forms to ask explicit questions about recordings and personal papers. Through 2029, the work took on a rhythm that was less dramatic but more infrastructural. I no longer felt the daily urgency to carry the envelope in my pocket. Instead, my stewardship manifested in policy drafts, in teaching, in small restorations to the house, and in the slow accretion of local practice. The ledger's digital search function was improved in January 2029 after a volunteer programmer created a tag system for the entries. Now the ledger could be queried for names, dates, and the recurring note, garden seeds. The piano was tuned in March 2029 and played in a small recital to raise funds for the Society's preservation efforts. My niece performed a new piece, one that folded in the left-hand ostinato my mother had favored. After the recital, several neighbors stayed to talk, to bring casseroles, to ask about durable powers and how to find trustworthy notaries. The house, by then, functioned as a node in a network of small, practical interventions. I am mindful, as these years have shown, of the tension between narrative closure and ongoing responsibility. The sealed envelope changed a will in a single instance years ago, but its afterlife, what we have made of it, has been the work of years and of many hands. In the archive it sits as an object with legal and civic resonance. In the house it lives as a soft-edged memory that surfaces when my niece hits a passing phrase on the piano. The cases cited in 2017 and the settlement of 2019 matter still. They are precedents in a ledger of practices. The 2020 statute reshaped procedural law, and the modest county initiatives in 2028 spread a modest, practical ethic. None of these developments close the book on what happened in my family. Loss and affection, misrecognition and restitution continue to circulate, but they do create pathways through which others can act with slightly more clarity. There is, finally, the question of what happens when the people who learned from this story are themselves older. I have that conversation almost every year with the Historical Society's director, a contingency plan that maps custody forward, names successors for the memorandum's oversight committee, specifies triggers that would open the envelope only if a judge orders it or if the last signatory of a named list dies. We set no date of unsealing, because we have learned that time is not a guarantee of truth, and because some secrets, like certain griefs, are not healed simply by time. Instead, we have made a plan that distributes responsibility, that institutionalizes the pause the wax seal represents. It is a plan that acknowledges fallibility, that archives make mistakes, that families change, that law can correct only so much. On some evenings, especially in autumn, I still sit at the kitchen table and look at the empty place where the envelope once rested when it was in my pocket. The house has become a repository of small practices, a place where people learn how to notarize documents, where a child's sticky note lives between pages of bills, where a university student can hear a clipped, anonymized voice and then leave with a question. I carry now more often, not a sealed object but a responsibility to teach continuity, how to set a boundary, how to write a memorandum, how to ask for help. Those acts are not spectacular, but they are durable. They move forward in municipal ordinances and volunteer lists and in the careful cadence of a woman at a piano teaching her niece an old phrase, and they will outlast any single resolution because they aim not to solve grief but to instruct how to bear it. By 2030 the niece was 18 and had begun a conservatory course that combined composition with archival studies. She arrived for holidays carrying a small notebook where, between sketches of chord progressions, she penciled questions about provenance and consent. "What happens to voice when the owner dies?" she asked once while we shelled peas on a bright March afternoon. I answered with the language we'd grown accustomed to. "We try to keep the terms of transfer clear, we build buffers, we name successors, and we teach practices that outlast any one person's memory." She nodded and then rewrote a bar of music, folding in the cadence my mother had favored. It occurred to me then that succession need not be purely legal, it could be pedagogical, a handing on of gestures and refusals. Institutional work continued in parallel. In April 2031 the Society and the University Library completed a scheduled media migration. The two archival WAV files and the lower resolution access copy were transferred to a federated preservation system that adhered to the WAGES reference model. The project was largely technical, checksum audits, format validation, and redundancy across geographically separate servers, but it was also emblematic. We had learned that the principal threats to memory were not only human curiosity but entropy and obsolescence. The migration took 6 weeks and produced a short procedural report that the Society circulated to peers. Several small repositories adopted the checklist. In June 2032 the niece presented a short piece at a regional symposium on memory practices and the law. She had taken the anonymized clip from the seminar archives and, with permission, used an excerpt as the basis for a set of variations. Her work did not reveal private details. Instead it interrogated the tonal shape of another voice's hesitation. The paper accompanying the performance, co-authored with a library scientist, argued for studio class pedagogy where students learn ethical redaction alongside transcription. The symposium speakers referenced the earlier papers from 2027 and 2029. Together they formed a modest canon on posthumous voice and archival care. Attendance remained small, but the conversations were sustained. Graduate seminars adopted the readings, and a practitioner in a neighboring state wrote to ask if our memorandum template could be adapted to a religious archive. Practical tests of the memorandum kept arriving. In late 2033, a storm damaged part of the Historical Society's roof. Water reached an exterior storage room, but not the vault where our sealed envelope and its digital surrogates were held. The Society's disaster response plan, which we had drafted after a risk assessment in 2029, proved useful. Volunteers moved at first light, dry ice and silica gel were applied where needed, and emergency conservators stabilized a few damp paper items within 48 hours. The exercise revealed one shortcoming. A single offline backup had been kept on a magnetic tape stored in a municipal building that, inconveniently, shared the same floodplain as the Society. We amended the contingency plan in February 2034 to mandate at least one off-site copy beyond county limits and to schedule annual migration audits. The family continued in quieter ways. My siblings attended one of the workshops in 2035, not to litigate but to learn. They spoke, in a tense but reconciliatory tone, about how the sealed envelope had altered perceptions and about the residual shame of legal conflict. We tended to avoid relitigating the past. Instead, the conversation turned to prevention. One sibling, who had never been fond of speeches, asked practical questions about how to list media in an estate inventory. Another offered to fund a small endowment for the Society's ethical accession work. Those gestures did not erase old wounds, but they did convert them into resources for collective care. Legal clarifications continued to trickle through. In 2036, a state appellate court addressed a different dispute about non-probate transfers of personal media. The opinion cited the memorandum model we had circulated as a useful guide to balancing private autonomy with community interest, though the court stopped short of prescribing a single formula. The decision did not overturn existing law. Rather, it affirmed that prudent transfer practices could be persuasive in contested cases. Lobbyists for eldercare organizations used the opinion to back model language in intake forms, and a small legislative committee convened in late 2036 to hear testimony on how to encourage voluntary archival stewardship without coercing